So the terms common law and precedent come up a lot when studying law, so it's important that we know what these terms refer to. So to start, common law originated in medieval England at the time of the Norman conquest in the year 1066 AD. And at this time, you get a confluence of several circumstances. So we get a new royal dynasty, and as a result of this new royal dynasty, you have new royal judges and little royal law. So when these new royal judges are sent off into the country to enact the king's justice, they have very little in the way of royal law to guide their decisions. And so what they do instead is they make up the law under the pretext of applying the natural law. So when parties would bring disputes before them, these royal judges would attempt to divine the meaning of natural law and decide the case in a way that they felt was just. As you could imagine, this type of case by case justice was not conducive to predictability. So, to solve this problem of unpredictability, these royal judges came up with the doctrine of stare decisis. And stare decisis is just Latin for stand by the decision. And this legal doctrine is what gives authority to judicial precedents. So, under this system, whenever a judge decided a case based on his interpretation of the natural law, that decision would create a precedent that future judges could look to whenever they were faced with a situation that was factually similar to the past precedent. So, the justifications underpinning the doctrine of stare decisis are predictability, and you will often hear judges say that it is better for a legal question to be settled than settled correctly. It is better for a legal question to be settled than settled correctly. Stare decisis is also justified by fairness, and in particular, the idea that like cases should be treated alike. In other words, a fair legal system should have similar outcomes when cases are similar. Now, the reason that it is called common law is because it was supposed to be the law that was common throughout the kingdom. And this was opposed to the local law that was practiced through the regions of the kingdom. And so, whereas local law was regional, the common law would be common throughout the kingdom. But in the modern sense, common law refers to one of two things. So it could refer to this idea of judge made law, and in particular, judicial legislation. Common law could also refer instead to the traditional rules of law created by English judges. In other words, common law could refer to the type of judicial legislation where a judge is making up a rule where no rule exists, regardless of when that occurs. Or common law could refer more specifically to the traditional rules of law that were created by Old English judges when those Old English judges were creating English common law. But on this point, I want to emphasize that common law is not the same as case law. So both common law and case law are, in a sense, judge-made law. But common law is judge-made law in a more pure sense, as the judge is inventing a rule where no rule existed. On the other hand, for case law, the judge is always making law under the pretext of merely interpreting and applying a rule that was created by someone else. So, case law, the judge is applying a rule invented by someone else. And you might hear people refer to this type of judge made law as interstitial, which just means gap filling. And so all rules, regardless of who writes them, have some ambiguities. And in the context of case law, the judge is creating law by resolving those ambiguities on a case by case basis. In common law, however, the judge is actually inventing the rule himself and then applying it to a case before him. But you could think of common law as a subset of case law because every time a judge makes up a new common law rule, he does so in the context of a case that becomes a judicial precedent. However, it is not correct to say that common law is the same as case law. So now that we have talked about the meaning of common law, we need to return to this idea of stare decisis. And recall that stare decisis is what gives legal authority to judicial precedent. And so stare decisis comes in two different varieties. So the first variety is known as a vertical stare decisis. And this variety holds that precedents of higher courts are binding on lower courts, deciding indistinguishable cases. So vertical stare decisis holds that when a higher court decides a case and thereby creates a judicial precedent, that precedent is binding on lower courts when they are deciding cases that are factually indistinguishable from the higher court's precedent. And this term indistinguishable is very important because many legal arguments in trial courts center around whether or not a precedent of a higher court is distinguishable from the case before the trial court. Now, these precedents of higher courts could be from either a Supreme Court or an appellate court. The next variety is known as horizontal stare decisis. And horizontal stare decisis holds that a court's own precedent is binding on itself unless overruled. And so already you should be able to see that horizontal stare decisis is not as strict as vertical stare decisis. For vertical stare decisis, a lower court has no choice but to apply a precedent to a factually indistinguishable case. Horizontal stare decisis contains this relief valve that a court could overrule its own precedent if that precedent is not working, and then create a new precedent to replace it. Here's what you need to understand about overruling a precedent, however. In order for a court to overrule a precedent, it is generally accepted that the court needs to have a good reason. It is also generally accepted that mere error is not a good enough reason to overrule a precedent. And this harkens back to the justification of stare decisis that the law should be predictable. And recall that predictability says that it is generally better that a legal question be settled than that it be settled correctly. And in this way, a court will be reluctant to overrule its own precedent, even if you can show that that precedent was wrongly decided. There is one final point that I want to make about horizontal stare decisis. And that point is that horizontal stare decisis is not applicable to trial courts. And so when a trial court decides a case, that decision does not become a binding precedent on the trial court. That said, most trial judges do want to be fair and are cognizant that it is not fair to have different outcomes for similar cases. And so, although horizontal stare decisis is not a formal rule in trial courts, the idea can still be persuasive to a trial court nonetheless.